Good morning. Welcome back to the Retirement Report. I'm Hank Parrott, your host. I've been talking about this new legislation, the Secure Act. This is like a big deal. This is going to have a lot of impact. You need to be aware of this, and you need to get educated about the impact it's going to have on you. One of the things that I was talking about just before the break was that of inherited IRAs. So we've talked a lot of times, and I've had Russ Cook here, the board certified estate planning attorney over in Brentwood. Russ and I have talked, many times about the importance as far as planning, in particular with inherited IRAs. So the goal of an inherited IRA is if you have not named a beneficiary, for instance, on your IRA, this could be a really big problem. All right, it could cause you to, the person that inherits that IRA would have to basically, so if you left it through a will, basically it was going to be to the estate, in other words, was your beneficiary as opposed to an individual, they would have to cash that out over no more than 5 years. So if you had a large, say $1 million IRA, you're talking about $200,000 a year, or $1 million all at once. Huge tax implications as far as what that might mean. For people that are inherited IRAs, if you're not, it's so important to watch. We were able to do what's called a stretch IRA. A stretch IRA allows you, what that means is the ability to stretch that out, not over 5 years, but over your lifetime. If you set up your beneficiary designations correctly, or if you're doing a trust, if you set up the language in the trust correctly. Now here's the implications of that. Inherited IRAs, so with your own retirement accounts, whether it's a 401k, a 403b, a TSP, thrift savings plan for you federal employees and military out there, whatever, or IRAs, traditional IRAs, and even with Roth accounts. Okay, these same rules apply with whether it's a Roth 401k, TSP, or Roth IRA. The same rules apply to traditional or Roth, and that is that if you inherit those, okay, during your lifetime, the ones that you have, let me back up a step. First off, if it's accounts that you've set up, that you have, that you're the owner of, you have certain protections under both federal and state law to protect your retirement accounts, so that if you had any kind of issues around personal injury lawsuits, trouble with the IRS, bankruptcy court coming after you for some reason. Bankruptcy court doesn't even have to be you filing bankruptcy. This could be somebody that you have a contract with that files bankruptcy that could put you at risk to having to pay things to the bankruptcy court. Well, one of the good things here is that the monies that are in your retirement accounts are protected. So you don't have to worry about, you might have other assets at risk, but these would be protected. You wouldn't have to worry about losing those. So the problem being that with your children, there's another issue that comes into place, and this is, unfortunately, divorce rates are quite high. So that's one of the concerns that we have with divorce rates being, is that what if you leave this money to your child and they went through a divorce? What happens to those assets? Could they, in fact, that in-law that's now an outlaw, all right, are they walking off with half your money? Half the money you've left your children, and that you've meant to go to your grandchildren, not to some, ex-spouse? And is there a way to protect it? And this is where those inherited IRAs come in again. So if your child was to get into any kind of trouble with regard to, again, even super creditors like the IRS and bankruptcy court, which can mostly get at most anything, cannot get at these retirement accounts unless, if it's an inherited retirement account, they can. And it could potentially that ex-spouse. However, if you left it to them in trust, then they would be able to, that would be protected. They'd be able to still have those assets, even if they lost everything else they had. That would still be a safety net for them and be protected for the grandchildren and on down the bloodline, however however that's set up for you. So those are some of the benefits of planning prior, all right, to the Secure Act. Because one of the other pieces is that it allowed you to stretch them out. So for tax purposes, we had some additional benefits. That inherited IRA was able to just take required minimum distributions. So the old rule was, if you had an IRA or retirement account, and you've left that to your children, so when they receive it, as they inherit that, they could then take, again, making sure that your beneficiary designations, assuming that that's done correctly, or your trust language is correct, it allowed them to basically just take required minimum distributions over their lifetime so they could stretch it out. Gave them more control. They could take more if they wanted, but no less, and that allowed them then to be able to plan to how they could minimize taxes on those accounts as they're taking money out. Okay, or stretch out, if it's Roth accounts, how to stretch out the tax-free benefits. Well, the new legislation that just passed, the Secure Act, and when I say just passed, President Trump has not signed it yet, but all indications are he will sign it before the year's out. And this new act called the Secure Act is going to then require that inherited IRAs be paid out over no more than 10 years. Now again, my example before, if you had a required minimum distributions always taken, you might only have to take on, say, $1 million IRA, you might only have to take, say, $30,000 or $40,000 a year out, give or take, right? Or some increment. Now, that would mean like at least $100,000 a year, or lumps in different years. There's going to be a whole new set of rules now when it comes to, or new strategies I should say, when it comes to how to take these distributions, and a lot more restrictions. So imagine if you're having to take out 2 to 3 times what you did before, okay, for these required minimum distributions, or excuse me, for this payout that's required, a 10-year payout at the longest. That could boost them up, right, your children up into higher tax brackets. This means for planning purposes there may be Roth strategies that are going to come into play again, even more so than they are now. Could be even more important in terms of how to minimize taxes on your estate. So if you think about it, your assets that you have, that you maybe are going to be leaving, to your children and grandchildren, the goal here is how do we keep more money in the family and less going out to the IRS, right? We don't want the IRS as our beneficiary any more than we have to in terms of what's required to pay. So this new law, this new rule, all right, that's being implemented with the Secure Act, I mean, obviously they're looking to raise revenue. Okay, that's what this is about. This is where this is getting passed into law. Supposedly this is to help us as far as our retirement accounts, and there are some benefits to be had within the legislation, but this is one of the ones that unfortunately can be detrimental with regard to taxation of our family unit, if you will, over generations. So how are we going to protect? There's going to be some strategies we can employ, but it's going to be even more important now to revisit that. And if you have trust documents that you've done, in the past year, that you've already got IRA language in there setting up certain distributions, well, this law, this new Secure Act for retirement accounts is going to change that. So you need to get a review of those accounts. There's going to be changes here that are going to impact it depending on how that language is done. There may need to be amendments done on your trust documents to protect you. So again, this is one of those areas it's important to get in and get reviews to see what the effect is on your personal situation. So I'm going to make it easy for you out there that need some help with that. You can call my office. The number is 615-376-5325. If you call the office, the first 10 callers, all right, we'll get you in and we can help you with regard to how this Secure Act is going to impact you. So again, if you're one of the first 10 callers to my office, 615-376-5325, we're going to do up a comprehensive plan. The Secure Act and impact there is just going to be one part of all that we will do for you at no charge. All right, I want to help you get a start here and also see if we might be a good fit as far as client. Maybe you become a new client, who knows. No obligation though. The big thing here, I'd like to do something for you to help you. So again, if you're one of the first 10 callers, 615-376-5325, we'll get you in. When you call in, I'm going to, again, a comprehensive plan. So that's tax planning, investment analysis. We'll show you based on what you're doing today, what your financial future is going to look like. All right, and then share strategies with you on how to improve that future, all right, to get even more out of it. How to minimize taxes on your retirement accounts. How to minimize taxes when you start taking that money out, in other words. Also minimizing taxes on Social Security benefits. How to maximize those Social Security benefits. Medicare, we get into healthcare costs and how to minimize healthcare costs and how to have a plan for paying for those healthcare costs. All of that is a part of the planning and more. We get into estate planning, tax planning, again, investments, tax-efficient income in retirement, tax-efficient investing strategies, showing you how to minimize taxes on your, year in, year out, as well as over your lifetime, of course. All of that, first 10 callers, 615-376-5325. And when you come in to see me, when you call the number, by the way, we've got people standing by, concluding tests. She'll take your information. She'll send you out a checklist of things to bring to your appointment with me. And when you come in to see me, I'll also give you a free copy of my book, 7 Steps to Financial Freedom in Retirement. And I cover in the book a lot of these same topics, so you'll have that kind of a little study guide to take with you. And we get into the planning pieces in the first 2 chapters. IRA Mastery in the 3rd chapter gets into taxes on retirement accounts and some strategies there. Chapter 4 gets into safe money, some of the safe money options that are available to you out there. Then we get into how the smart money invests in the stock market and talk about strategies there and modern portfolio theory and a lot of things I talk about, of course, each and every week here. We get into, on Chapter 6, long-term care and planning there, how you can cover long-term care costs and know it's not always about insurance. There are other ways to do that. And then, of course, Chapter 7 is on estate planning, and that's one of the areas with this new Secure Act that is really going to be changing the rules. So, again, thinking in terms of this new change with inherited IRAs requiring that they be paid out in no more than 10 years. So you have 10 years or less, that money has to be taken out of those retirement accounts. It's going to open up a lot of planning needs and need for planning, if you will, with regard to inherited IRAs and for your planning in your trust, and if you're, for your family, how you're going to, again, minimize the tax impact over your, not just your lifetime, but of course that of your children and your grandchildren and so on. All right, so there's a lot about the Secure Act there. This is why, and we're going to be getting into more, as I said, in future weeks here. And in fact, we're going to cover, I'll get Russ back on, we're going to talk about the estate planning document piece in more detail. We'll get Friday on, we'll talk about some of the tax implications again in more detail. And again, on the retirement piece, when it comes to your planning, can't emphasize enough how important it's going to be. And this is, there's no, sometimes when they pass legislation, it's phased in. It gives us a few years to kind of, get ready and develop some strategies ahead of time. Here, we don't have that. I mean, here it is, the end of the year, and this is going to go into law effective in 2020, meaning it's going to affect even some people for 2019. All right. So, all right, we're going to talk about that some more, but first we're going to take a break. Join me here. We'll be right back on the Retirement Report.